everybody, my name is Michael Quinn. I'm one of the directors of the Quinn Group. This month on Quintessential TV, we'll be discussing domestic access to information and documents by the Australian Taxation Office, the ATO. At the commencement of a review by the Australian Taxation Office, the usual practice of the ATO would be to request information informally through a request for information, which is often called an RFI. The issuance of an RFI proceeds on the basis that the taxpayer is cooperative and will continue to be. Given the informal nature of such requests, they are normally directed to the taxpayer or their associates rather than third parties. As many may be aware, in mid-2017, the ATO commenced the Top 1000 Tax Performance Program, aimed at obtaining additional evidence to achieve greater assurance that the largest 1,000 multinational and public companies are paying the right amount of income tax. The key tool that was used by the ATO in this program is the Streamlined Assurance Review. This commences with an RFI, which asks taxpayers to provide information and documents covering the following four broad areas. 1. Alignment between accounting and tax results. 2. Tax governance and risk management. 3. Significant and new transactions. 4. Tax risks flagged to market. This Streamlined Assurance Review was intended to be a 4-month expedited process designed to provide the ATO with sufficient materials to make an informed assessment as to whether it has obtained the necessary assurance or has identified areas of tax risks requiring greater examination. The information which the Commissioner seeks under such request may be both domestic information and information held offshore. Compliance with the Streamlined Assurance Review, RFI, as with any RFI issued by the ATO, is voluntary. However, failure to satisfactorily comply may give the Commissioner cause to resort to its formal powers under Division 353 of Schedule 1 of the Tax Administration Act 1953 to obtain the information and documents. Prior to 1 July 2015, these powers were contained in sections 263 and 264 of the Income Tax Assessment Act 1936. From 1 July 2015, the power has been contained in section 353 subsection 10 of Schedule 1 of the Taxation Administration Act 1953. Publicly, it was suggested that this was just a consolidation of various access powers into a single location for multiple legislative purposes. To allow for consistency in administration, however, Section 353 subsection 10 is, in some aspects, broader than prior provisions. Under the current provisions, some of the variations include the requirement to attend and give evidence before a person is not restricted to an authorised officer, but merely a person authorised by the Commissioner. This simplifies the process of using external barristers to conduct such interviews, whereas under Section 264, they had to be officers appointed by the Commissioner. There is no longer a requirement for the Commissioner to identify a taxpayer in the context of a requirement to attend and give evidence, or in the context of a requirement to produce documents. Under Section 264, the notice required the identification of the relevant taxpayer. If you need help in this area, please contact one of our tax lawyers. If you'd like to know more about domestic access to information and documents by the ATO, please contact us. You're welcome to email us at info@quinns.com.au. We'd love to get your feedback with relation to Quintessential TV, so please like, comment and subscribe. We look forward to seeing you all next month. I'm Michael Quinn. Bye for now.